Hello, everyone. I'm Athrea Mothur, the Judith Bresler Fellow at the Center for Art Law, and I'm so happy to welcome you to the Visual Artists Immigration Law Clinic. We would like to thank Jillian Carver and QArt Foundation, who are the co-hosts of this clinic. QArt Foundation is a dynamic visual arts center that's dedicated to creating career and educational opportunities for emerging and under-recognized artists. They have various core programs, which include solo exhibitions and an annual fellowship for emerging curators, as well as different mentorship and publication opportunities. I would also like to thank all of our volunteer attorneys who are here with us today, and without whom these sessions would just not be possible. So thank you so much. But before we begin, let me let you know a little bit more about the Center for Art Law. We're a Brooklyn-based research and education nonprofit, and we are dedicated to offering resources and programming for a vibrant arts and law community. Through our website, our newsletter, events, we try to disseminate information and keep our audience up to date on all art law related news, programs, cases, movies, publications, and we even hold clinical events such as ours today to connect different artists and attorneys together to guide them in certain areas of law. I would encourage you to take a look at our website and QArt Foundation's website as well. Subscribe to our newsletter and consider becoming a premium member to know more about our events. We would also love for you to check out our social media and our Instagram, where we visit tons of fun and fascinating galleries, museums across the globe. We were in London for a little while and we posted more photos in New York City. Apart from this, we also have different events coming up, including a workshop on copyright. We have a CLE on estate planning. We have a fan art session. And even in December, we have artists who are lawyers and the creation of virtual galleries during a pandemic. We also have our legacy and estate planning clinic coming up, which is scheduled in December as well. And we will be sending across the details for all of this on our newsletter, and you'll be able to check out all of the events on our website as well. A few of the general housekeeping items. The program is currently being recorded for archival purposes, and we'd love to see you though, so please feel free to keep your camera on. To those of you who have registered for the consultation sessions, we will begin at 4 p.m. and we will be assigning you into different breakout rooms for the sessions. After the event, we will be sending across a handbook for the clinic, and that contains information about the visas, the process, links to other helpful resources, and the bios of the attorneys who are with us today. If you have any questions at all during the presentation, please feel free to drop them in the chat box below, and we'll be discussing them at the end of the presentation. Now, finally, let me introduce our keynote speaker for today, Rakhel Milstein, who is the founder and CEO of Milstein Law Group. So Raquel has been practicing immigration law for nearly 2 decades, focusing on extraordinary ability visas and green cards. She handles all types of immigration matters, including standard work visas, green cards, family-based cases, and she has extensive experience resolving complex immigration cases in federal court. She also prides herself on finding creative solutions for clients to allow them to live, work, or train in the US. So without any further ado, Raquel, the floor and the Zoom screen is yours. Thank you.
Thank you so much. Thank you. It's such a pleasure to be back. I really enjoy doing these sessions. So thank you. And what a fantastic organization, and all the work you do all over. It sounds incredible. Well, today, as Athrea mentioned, I'm going to be presenting the immigration information for artists. There's obviously more options that I'm going to go into, but primarily I'm going to focus on the O1 visa, which I think many of you are somewhat familiar with. So I'm going to just share my screen and get up my PowerPoint. One sec. Okay, hope everybody can see this. Let me see how to get it started. Sorry, bear with me. Can you guys see my screen?
Yes, we're able to see it.
Great, great. So I was going to start off with just an overview, because the O1, so there's visas and there's green cards. And so just for those who are entering into immigration here, visas are short-term benefits that allow you to be in the US and most of the time to work in the US. So the O1 visa is a work visa, and it's not only available to artists. And a lot of times people refer to it as this artist visa, but it's actually available to all professions. So keep in mind that we've worked with all types of professions, ranging from filmmakers, curators, art critics, multimedia artists, people behind the scenes, art management coordinators, curators, art writers, and performance artists, graphic designers, and so many others. But there are many people who can qualify for O1s outside of the arts. It applies to those who are in the sciences, athletics, business, education, etc. So it's not just limited to artists, it's available to so many professions. But within the arts, there are so many ways to create an O1 case. In essence, the O1 is a 3-year work visa. And it is also available in major motion picture and television. So I know a lot of visual artists work in multimedia, and a lot of times, you're working on films and television, as well as, on stage or on canvas or what have you. So keep in mind, there really are no limitations when it comes to creating an O1 case in your profession. Really, almost anything is possible as long as you have the right kind of evidence to support it. Okay, so I break down the O1 into 4 basic components that I tell all clients you're ultimately responsible for. And I'm going to get into each one in more detail, but just so you have a brief overview, the O1 is basically comprised of these 4 elements. You have a US petitioner. Some people refer to the petitioner as a sponsor, but the O1 is actually a petition. It's not an application, it's a petition we submit to immigration. And so you need 1 US petitioner. You need evidence that you have work lined up, because like I said initially, it is a work visa. So we need to show that you have potential work that is lined up that you intend to do. The thrust of the case is evidence of your extraordinary ability, and I will get into all those details. And then ultimately, we submit letters of recommendation, and those are your responsibility to have signed. So those are really the 4 essential components of an O1 visa, regardless of what your profession is. So what is an O1 petitioner, right? So I think it's easiest to take a step back and think about it as in a regular work scenario. Take away the arts. Let's say you're a lawyer coming to work at Milstein Law Group. Milstein Law Group would be your employer petitioner, and then you're the beneficiary. What happens in reality when we deal with a lot of artists is that you want to work with multiple employers. Sometimes you're working on your own, you're creating your own artworks, you're exhibiting your own artworks. So in the situation where you're not working in a traditional employer-employee situation, but rather something that's a little bit different, whether it's multiple employers, whether it's creating your own artworks, that's a situation where now your O1 petitioner isn't your traditional employer, right? So the O1 petitioner can act as 4 different capacities, okay? Number 1 is the only real requirement for the O1 petitioner is that they must be a US entity. So any US company, any US citizen, or any US green card holder or permanent resident can be your O1 petitioner. Many people think I need to have someone who's really prominent in my field, or I need to be sponsored by a management company or an agency. It's all false. The only requirement is that it's a US entity. So my biggest recommendation, actually I think the most important consideration for the entire O1 case is you pick someone you trust. The petitioner has power. The petitioner holds the keys to your O1 visa. The petitioner can send a letter to immigration at any time and say, I wish to withdraw the case, and then you have no visa status. So you want to carefully consider who is your petitioner. And I have to say, there have been countless times where I've met with people who've said, well, I have a petitioning company. They're going to serve as my agent for the case. And I said, well, who are they? They don't know them. They were recommended by somebody. That's not a good idea. You do never want to pick somebody you don't know who they are. So the O1 petitioner is a really important consideration. And in my opinion, the most important element is trust. You need to trust this person, and they don't need to be in your field. So any US entity can be your O1 petitioner. Then there are 4 ways that a petition can be prepared for an O1. Number 1 is Like I said, you can work on an O1 where your employer is your petitioner. So if you're being hired by a gallery and you're working as a manager there, the gallery can be your petitioner as your employer, and then you're the beneficiary. You can work 3 years for that employer if they sign off on that. And that's a standard work visa scenario in the US. The alternative is setting up a case where you have multiple employers. And I would have to say that this is the most common setup that I've seen or with our clients by far. The multiple employer O1 scenario is set up where you have one US petitioner, and again, any US citizen, any US green card holder, or any US company. And then you have multiple potential employers offering you various jobs over the course of the next 3 years, keeping in mind that all the work is always specific to a profession, right? Every work visa is always specific to a profession and an employer's. So if you have multiple employers, these employers are those who you're going to be able to work for in the future. And you would be working for them in this specific capacity, whether it's a multimedia artist or whether you're a graphic designer or whether you're a performance artist, whatever it is, that's the only type of work you're going to be able to do under an O1 visa. So the multiple employer case is really great, gives you the most amount of flexibility. And I have to say, just as a little side note, during COVID, when so many people had to take unemployment, I had countless calls from our O1 clients because they were concerned, could they take unemployment like everybody else was who were US citizens? And with a multiple employer O1, you had way more flexibility in terms of taking on those kinds of benefits, though I was trying to discourage people from doing it, than let's say if you were working just individually with one employer on your O1. So there are a lot of great benefits to having multiple employers. Keep in mind, those employers do not have to be US employers. You could have employers who are foreign employers who are offering you work to do in the US. So it's not limited to just US employment. Again, the only thing that has to be US in your whole case is your one US petitioner. Okay, so you can set it up with a single employer, you can set it up with multiple employers, you can set it up, so, and these last two scenarios are usually much less common, but one is that you have an agent who's actually in business as an agent. So they're like a talent agent and they're guaranteeing you employment. So they basically act as an employer. They say, we're gonna act as your agent, but we're guaranteeing employment and she will get paid X amount per year. That usually only happens for those A-list celebrities, but that does happen from time to time. And then there's the final scenario where you have a foreign employer and your US petitioner is acting as an agent on behalf of your foreign employer. So let's say you own a film production company in London and you want to be able to work for your company in the US. You have no interest in forming your own company in the US. Well, that US citizen friend or relative can be your O1 petitioner representing that foreign employer. So those are the four scenarios. The most common one is multiple employer, especially amongst visual or fine artists that we've worked with. Okay, so now when I talk about the O1s, sorry, I need to get this into the presentation mode, but I'm not able to do that. So I'm going to keep going this way. Okay, so when I break down the O1, I essentially break it into two parts. About 90% of the case really focuses on your past achievements and successes. The remaining 10% focuses on your future work, right? Who's your petitioner? Who will be your future employers? And so because the thrust of the case is really about your past achievements, it's really important to get into that and discuss the type of evidence that's needed. So I always bring people back to the regulation because that's where it was all born, right? So the O1 regulation states that either you have a major award, right, which most of us don't have, right, or you can satisfy 3 out of these 6 criteria. So either you have, and what's interesting is that you can have received the award, or nominations count only with the O1B in the arts. So it's important to know if you've been nominated or received any major award, which is sort of national or international in scope, then you could satisfy an O1 without even having to satisfy the 3 criteria. But I'm going to get into these 6 criteria because most people don't have this big award. So here are the 6 criteria, and I'm going to just break them down for you. I'm going to start with the second bullet point. Okay, so we nickname this one national or international recognition. This category is documented with press by or about you. So if you've heard your friends talk about, do you have press? You need press for your O1 case. Well, the truth of the matter is it's not essential. It's not fatal if you don't have press. But the reality is the officers at immigration are people. And when they see press or they see awards, they see evidence that's really easy for them to realize your achievements, it makes their job easier to prove your case. So the national or international recognition category is a great one to get. Either it's about press about you, so maybe reviews of exhibitions or interviews or profiles on you, or if you're an art critic or a curator or a reviewer, whatever it might be, and you publish articles, you can also satisfy that category with your own writing or published work. So that's a great one to go for, whether or not you have coverage, as long as you maybe publish work in your field. The second one that I want to just touch on quickly is the second to last one, and we nickname this one significant recognition, because significant recognition is argued for every single O1 case I've ever done in my life. Significant recognition is something that everybody can get. So it's based upon expert testimonials, right? So what is that? It's letters of recommendation from well-known individuals in your field who can speak about your contributions and your achievements in your field. So you want to brainstorm, think about some of your best contacts. And a lot of you are probably recent graduates who are on OPT, who are looking to see how they can stay in the US. And so yes, maybe some of your best contacts are your professors. But the key with O1s is this. They're for professionals, and immigration officers only consider professional achievements. So as a rule of thumb, you can't use any school-related achievements for your O1 case. Whether or not you went to Juilliard and you were the best musician in your class, immigration really doesn't care. And in fact, what I've seen time and again is that it hurts your case. No matter how important your academic achievement is or how well your professor can speak about you and your achievements in your class, the standard for an O1 is professional level. It is about how do you, where do you stand amongst your peers and how high are you on that level? And with any kind of academic achievements, immigration's point of view is, look, if this was an opportunity only available to students, it's not a real assessment of your professional talent. So they don't consider it. And they tend to sometimes completely discredit the entire case if they see one mention to a student-related achievement. So not a good idea to keep it in. You always want to eliminate any student-related achievements. So that was a long-winded discussion about the significant recognition category, but my point is that yes, you can use prior professors as references for this category, but no, they can't talk about your work as a student. As long as they know about your professional work or can speak to your achievements outside of school and on a professional level, then absolutely, those are going to be great letters. But it's very important to keep in mind, make sure that they don't talk about you as a student. It's just not, it's not a good idea. Okay, I'm going to bounce back up to the top now. So in general, we always argue the first and the third category together. And I think you've got to see these categories to understand why you need certain evidence. These two categories both overlap a lot, right? We have to show that you have and you will perform a lead or starting role. One of them is in productions or events, and the other is for organizations of a distinguished reputation. So in reality, let's say, for instance, you have an exhibition at a gallery, right? Well, maybe we would argue both categories for that exhibition at the gallery, because if you had a solo exhibition at that gallery, well, that's evidence of a lead or starring role at an event that had a distinguished reputation, assuming we also have reviews of this exhibition. But then we can also talk about how it contributed to the gallery as a whole and how that was critical to the success of the gallery. So this is why those two categories, we tend to argue them together. There's no real reason to separate them in most cases. So those four are generally the ones that are most often used, right? The first three and then the significant recognition category are the most commonly used categories for the O1 cases. Commercial or critically acclaimed successes are great if you've been in like performed in any kind of festival or production or event that was like, either was sold out, had major box office sales, or had massive critical reviews in the media and things like that, then certainly we go for that. And then unfortunately, the last category, I have to say amongst my artist clients, is almost never used, but it's for high salary. If you're paid significantly more, if you've sold artworks that are significantly for a high amount of money, then obviously we would use that. Commissioned work, any work that has been placed in private or public sales is also really good. So those are the 6 categories. This is what you always want to think about when you're trying to collect evidence of your achievements, because this is what your lawyers are looking for. So this is why we go into the certain types of evidence we're looking for. So the next slide is all about that. Like I said, we try to make the job of the immigration officer as easy as possible to approve your case. Published work, like any media attention, and keep in mind, they're not watching anything, they don't listen to anything. These O1 cases are always limited to paper submission. So any kind of reviews or profiles you can get in the media is always excellent for your case. Again, makes the immigration officer's job easy. And then I mentioned also, if you publish your own work in your field, even if your images have been published in certain publication, that also counts. Awards and prizes are excellent. And in fact, I love to include residencies as some awards or prizes because they are selections of some degree, and I think they're important. Letters of recommendation. I mean, I know, look, 20 years ago, we would submit 10, 15 letters. The immigration officers don't read them. We spend months preparing these cases. Immigration officers have 15 minutes to review your O1 case. There's no way they're reading 15 to 20 letters. They don't care who they're from, So what you do is you select your strongest sources, your strongest people, and we prepare these letters of recommendation to touch on those specific categories that I just went through with you, so that we have the strongest presentation of your case. And then other things, right? We have to show that these events actually took place, right? We can say there was this exhibition, but if we have nothing to show for it, immigration is going to toss it out the door. So programs, playbills, advertisements, anything that's sort of confirming that these events actually took place, that your roles you actually perform these roles for these organizations or events, that's important. And then the last bullet point is just for the commercial successes, which, is really based on those kinds of stats. That's the O1 in a nutshell. You always want to allocate at least 6 months to an O1 case. It takes the lawyer generally 2 to 3 months to prepare a case, and then it takes immigration on average somewhere around 2 to 3 months to process a case. That's not a hard fixed timeline. That's just their general processing times that we see. Some cases are approved in a week, and guess what? Some cases are approved in a year. So if you want a firm turnaround time, you can always pay the immigration services for expedited processing. It's called premium processing, and they'll give you a decision in 2 weeks. So that's really kind of the nuts and bolts of the O1. I do have the H-1B we can touch upon, because the H-1B is really the standard work visa in the US. It's the one you hear the most about. For those of you, and I'm assuming most of you who are recent grads or soon to be grads, a lot of times you have the OPT, which is your optional practical training post-graduation. You get this 1-year work permit. It's great. Take advantage of it. Do as much work as you can during that OPT time. But then once that's starting to expire, if you don't qualify for an O1 and you don't have these types of, evidence to prove your case, sometimes your only option is the H-1B. So the H-1B is a standard work visa where you have a company sponsoring you for a position that requires your specific degree, okay? The type of degree is really important. There's a specific salary that must be paid to you, and it's dictated by the Department of Labor. And for most private employers, there's only one time of year you can apply, and that's in April, because there's an annual lottery. There's only 65,000 H-1B spots a year, another 20,000 for those with a US master's from a nonprofit university. And those, so what happens is there's an annual lottery. I mean, there were over 200,000 applicants last year, let's say 85,000 spots in total with the master's degree. That gives you a sense of, there's not a lot of security, but you do find out about your selection relatively quickly. So you file for your lottery in March, and then you find out in early April whether you've been selected. Just to give you some basics about the H-1B. You need that job offer, and the employer is required to pay all the fees. The beauty of the O1 is anybody can pay the fees. So look, the reality is it's not easy to find a job. If you do get a job, it's even harder to get a company to sponsor you for a visa. So a lot of times if you can pay your own O1 fees, well, then the employer is usually much more willing to go along with that case and sponsor you or be a potential employer. But with the H-1Bs, they have to pay all the fees involved with the H-1B case. And the H-1B has a 6-year max, unlike the O1. So the O1 is issued in 3-year increments. It can be extended for 3 years. There's this misnomer that they're only extended for 1 year. Not true, only in certain circumstances. So with O1, you could theoretically extend your O1 for 3 years, every 3 years for the rest of your life. Whereas the H-1B, you only get 6 years max. Then you have to switch to something else or leave the country. I think I already told you about these procedures. We have to file in the lottery in March. Now it's an electronic registration, which makes life easier for everybody. And you find out whether you've been selected in April. The end of this is just really some basic considerations to think about. There's always a green card, and I think a lot of people ultimately want to get the green card. No visa turns into a green card. An O1 doesn't turn into a green card. An H-1B doesn't turn into a green card. The green card process and the visa process are completely independent of each other. A lot of times employers will sponsor you for a green card once you've worked for their company for a while, but just know that they're totally independent and separate. I always recommend that you hold an underlying visa status throughout the pendency of any green card application you go through, because immigration makes mistakes and more frequently than you'd like. And so you need to always be prepared for anything. It's sort of like, think of it as insurance, right? It's just underlying your visa and your green card process. There are only 2 types of green cards that allow you to self-sponsor. You can just pop this in your back pocket. It's good to know. There's the EB1 extraordinary ability, quite similar to the O1, but a much higher standard of extraordinary ability. And then there's an EB2 national interest waiver. Happy to go into that at another time, but just know there are 2 ways that you can actually self-sponsor for a green card. It's also important to know, and this is also based on the assumption that most of you are on OPT or are in school, that when you're on an F1 student visa, you are required to demonstrate that you are only here temporarily, right? You're going to come here to study and then you're going to go home. So it's important to consider that if you are thinking about applying for a green card or for permanent residence, because there are timing considerations, and obviously this intent is a big deal. I always encourage everybody to maximize all the benefits you can get from immigration. So if you're wondering, should I apply for OPT? Like, absolutely apply for OPT. You know, it's a great benefit, gives you so much flexibility. You don't need sponsorship, so it's really great. You do need to work, right? You can't accrue more than 90 days of unemployment, but you should do it. If you're eligible for STEM OPT, absolutely take that on. It's amazing. It's a great benefit, so you should do that. This is a little bit more about other considerations. I'm not sure if any of you are on J1s. J1s also can be for students. So there may be some of you who hold J1 visas. If you do, you need to be aware that if you are subject to a 2-year home residency requirement, and you would know if this is you, that you're not able to really apply for any other type of work visa other than the O1. So you could still apply for the O1, but what you have to do is go home, get the visa stamp at the consulate, and then enter the US to get the O1. You're not able to do what they call a change of status from the J to straight to the O1. This does not eliminate your 2-year home residency requirement, just sort of postpones it post your O1. Also, some J1s are eligible for academic training, which is similar to like an OPT. It's a great benefit. Take advantage of it if you have it. Some visas allow spouses to work, so O1s don't. If you're married and your spouse is also looking for a work visa, it's not a 2-for-1. You can't get, your spouse isn't allowed to work on the O1. So the J1 spouse is allowed to work, and E2 spouses, and L1. So these are just things to consider when you're thinking about what kind of visas you want to go for. And finally, the RFE. The RFE exists amongst all immigration cases. An RFE is a request for additional evidence. No matter what kind of case you submit to immigration, there's always a possibility that immigration will issue you a request for evidence. I think I speak for all lawyers when we say we do everything possible to avoid an RFE. Nobody wants it. They're not fun for you, and it's not fun for us. But they happen. And so sometimes it's nonsensical, sometimes it's pure incompetence, sometimes it's legit and there's more evidence that needs to be submitted. Just know that nobody knows what the RFE is looking for until we receive it. It's always mailed to us unless you filed with premium processing, that expedited processing. If that's the case, then they'll fax it to you, but know that it's a possibility. And the reason it's important is sometimes there's additional costs involved, and sometimes obviously there's additional delays in the processing of your case. So these are just things to think about when you're sort of exploring immigration and how and which way you want to go with it. If you're married, thinking of spouses, the timing is always important. And obviously there's a lot of cost considerations as well. But that is my little seminar in a nutshell. I'm going to stop my share and pass it back to Atreya.
Thank you so much, Raquel, for your presentation. It was really helpful, even for
Thank you.
my OPT. So definitely lots to consider. We do have our consultation starting very soon, but quickly, we do have a question in the chat as well. One of the questions is whether it's possible to start petitions such as the O1 without job offers.
You can always start it, right? Because 90% of the case is really building it and preparing that the substance of it, but you need the job offer before it can be filed. So certainly it can be started, but it cannot be filed without the job offers.